Very good evening. A wonderful start to a lovely weather and a festive month. It is such a pleasure to have everyone here. I am Gitu Singh. I'm a partner with KPMG Forensic Practice. And on behalf of KPMG and the KPMG Forensic Practice and all my fellow partners, I very, very warmly welcome all of you here. We are very glad to be hosting the second International Arbitration Dialogue, which has been organized by the Indian Arbitration Forum. I will please request a very good friend, a leading practitioner, Tejas Karya, who is a partner and head of arbitration with the leading law firm Shardul Amarchand, and also the director of IAF, to please come on the stage.
Honorable Mr. Justice Varma, Mr. Philip Jeyaretnam, Mr. Banerji, good evening, all of you. Welcome to the event today, which is hosted with KPMG and IAF. I just thought we'll just give you a brief introduction to IAF. I'm sure many of you know about Indian Arbitration Forum. It started almost a decade before in 2013, where all the arbitration practitioners came together and we realized that there is a need to form an arbitration bar of the lawyers who are already specializing in arbitration and doing arbitration as a main practice. India is always criticized that arbitration is a part-time profession and we do it in the evenings or in the weekends. But we all thought that no, that is not the correct approach, because when we go to London or Singapore or any other jurisdiction, we realize that the arbitration is a serious business and we do it from morning to evening, 9 to 5, Monday to Friday, not on the weekends. And even if we have weekend, we will take it off or prepare for the hearing on Monday and not work on the weekend. So that was the idea behind IAF. We have come a long way in this journey of IAF. We have members across the law firms, leading arbitration practitioners, senior counsels, and also like-minded people who have worked together to promote arbitration in India. We support all the events and we have also tried to develop the soft law. We all know about the IBA and their guidelines. Likewise, we have an IAF guidelines on conducting arbitrations. So these guidelines provide how an ad hoc arbitration should be conducted. So it's a step-by-step process where we have the soft law which can be adopted in the first procedural order itself, and then it becomes part of the procedural order. So IAF guidelines can be adopted for conducting the arbitration. We have guidelines for virtual hearings, which provides, and that came during COVID time, and we realized that there was a need to have guidelines for virtual hearings. So we have taken the best practices across and formed the guidelines, where we had support from all the leading arbitral institutions, law firms, judiciary, and we have prepared that. Apart from that, we also are focusing mainly on promoting arbitration for the youngsters and younger practitioners who want to specialize in the field of arbitration. There is always a need to grow the field of arbitration. There are landmark judgments which Supreme Court and High Courts have has been coming up with, and we as an arbitration practitioners are supporting that. And Justice Yashwant Varma invited the bar for one of the cases which has become landmark in India, where the arbitration practitioners came together and supported the making of the law or clarifying the law as it stands. So that way IAF has achieved a lot, and we are proud to be associated with the event today. So on behalf of IAF, I once again welcome you and looking forward to this fruitful panel discussion. Thank you.
Thank you, Tejas. I would like to please take the opportunity to introduce to you our speakers. I have to say, so my extreme apologies. I have to acknowledge acknowledge that I'm not even worthy of making introductions of any one of you. We all know you very well, but I think what happens with professionals like us is every now and then we do like to remind ourselves of the achievements of our senior colleagues. And in the spirit and dignity of that, please do allow me, I would really like to make some of the introductions. Introducing first Honorable Mr. Justice Philip Jeyaretnam. Justice Philip Jeyaretnam stands as a luminary in the legal fraternity, as we all know. He's currently serving as the president of the Singapore International Commercial Court, the SICC. His remarkable journey spans across diverse legal domains and notable accomplishments, both as a legal practitioner and as a jurist. As a legal practitioner, his expertise traversed various facets of law, particularly in commercial litigation, arbitration, and construction law, earning him widespread recognition in major legal publications. His leadership was evident as the managing partner of Roddick and Davidson from 2011, eventually assuming the role of the ASEAN CEO following its amalgamation with Dentons. A very warm welcome, Mr. Jeyaretnam. Next, I would please like to introduce Honorable Mr. Justice Yashwant Varma. Honorable Mr. Justice Yashwant Varma, presently serving as a judge in the Delhi High Court, embodies an illustrious legal career marked by exceptional expertise and notable contributions across various legal domains. Elevated to the bench as an additional judge of the Allahabad High Court in 2014 and subsequently sworn in as the permanent judge in 2016, Justice Varma's judicial tenure showcased his adeptness in adjudicating various legal matters. His judgments traversed a wide spectrum spanning service law, constitutional law, property law, writs challenging state authorities, and criminal law, setting significant precedents. A very, very warm welcome, Sir Mr. Justice Yashwant Sarma. The third speaker with us today is Senior Advocate Mr. Gourab Banerji. Mr. Banerji is an eminent legal practitioner with an illustrious career, boasts a distinguished journey marked by exceptional academic prowess, legal expertise, and significant contributions to the Indian legal landscape. Mr. Banerji's remarkable expertise predominantly centers on commercial matters, notably commercial arbitration. His extensive practice before the Supreme Court of India encompasses a multitude of domestic and international commercial arbitrations, earning him recognition and appointments to various committees dedicated to the Indian arbitration law. Mr. Banerji's contributions extend beyond the legal practice. He has played a pivotal role in recommending changes to the Indian Arbitration and Conciliation Act and represented the Government of India at various international forums, demonstrating his expertise and commitment to the legal advancements. With this, we warmly welcome Mr. Banerji today for this dialogue. I would please like to inform all of you that our media partners, the EBC group, is going to be publishing this entire event by way of a book. And I'm also given to understand by the EBC representatives that this event will also be streamed live on various social media platforms. The EBC group is the intellectual giant in legal publishing. It has traditionally published a wide range of legal commentaries, student text, law reports, and digests. Today, its products include pioneering works in the print and the electronic media. EBC has pioneered legal databases for making law easily accessible in the electronic medium. This has appeared in a revolutionary form in the electronic medium and in the form of SCC Online, which is a web edition. It is one of the most comprehensive and well-edited legal research tool for Indian and foreign law. EBC will also be publishing the Arbitration Dialogues series in the form of a book. Today, we are covering the event on the SCC Online blog. With this, a very big thanks to EBC for stepping in as the media partner. I will now request our speakers to commence the panel. Thank you so much.
Thank you for that very... Can you hear me? Yes. Yeah. Thank you for that very kind introduction to the panel. Before I start on the topic, which is the role of the commercial courts as to whether they supplement or supplant arbitration, because after all, we have members of the IAF here. I just wanted to thank both KPMG and IAF for giving me this opportunity. And I must confess at the beginning to an imposter syndrome, because sitting on my left, Justice Varma, who I have known since he was a lawyer, and possibly one of the most successful commercial lawyers of his High Court, possibly the most successful. And then on my right, you have Justice Jeyaretnam, who, you know, a la Dr. Singhvi has been a child prodigy. He was designated a senior at 38. So you can imagine the sort of brain power on the left and the right, plus a first class at Corpus Christi, if I'm not mistaken. So I'm suffering from imposter syndrome, but what is good about this is I'm merely the moderator. So you'll be hearing the judges, though it says moderator / speaker, I'll be the one asking the questions, and you will have the benefit of judicial wisdom. So on that note, let me start off by first asking Justice Varma a little bit about, you know, the Commercial Courts Act. It's an act of 2015. If he could tell us a little bit about why there was a necessity for this, how it was introduced, and then we'll move on to the substance of the provision. So a little bit about the background, particularly since he's been a commercial lawyer and then a commercial court judge.
Well, I think in 2015, it started off much earlier, but 2015 represented a paradigm shift so far as commercial litigation was concerned in India. And the 2015 Act, in fact, essentially represents our urge to jettison the archaic civil procedures which used to bog down litigation in India. And it was just a more emphatic legislative measure of ensuring that commercial litigation was governed by a totally new and in tune with time rules of procedure which laid down specific time frames. We gave impetus to pre-institution mediation. So these were all steps indicating that we needed to move away and come up with a new way of handling our commercial litigation.
And just to supplement what Justice Varma said, since I'm moderator / speaker, so I can take the liberty of adding some, shall we say, gossip / sort of history. When they, in 2003, for Justice M.J. Rao was our Law Commission chairman. Many of you will know him, very academic bent of mind. He proposed this commercial court because he found 4 US judgments and 2 English judgments which criticized our system of courts and said they were hugely delayed, and therefore they sort of grabbed jurisdiction. But interestingly, there was a lot of resistance to commercial courts, as Justice Varma also remembers. There was a lot of resistance. They said, why are you having 5-star courts for rich people? And it was only later in 2015 when there was another law commission with Justice D.K. Jain that this was pushed through in 14-15. So it's not been quite an easy ride, but we have this act now, and obviously I will be asking Justice Varma a little more about how this act works, what are the provisions, and then we'll come to the interplay between arbitration and of course, the commercial courts. But I will switch to my right. I will ask Justice Jeyaretnam, who, of course, is very familiar with Singapore. I remember the first time I met him, he was heading Rodike, which then became Denton. So he's a leading senior counsel. So he's seen everything from both sides. So my question is, and I will not jump to the SICC because I will of course come to that, but I had a preliminary question. How normally, if you have commercial disputes in Singapore, or if you have commercial arbitration in Singapore, say between Singaporeans or a domestic matter, does that go to a commercial court, or does that sort of, is there a Commercial Courts Act, or how does that work? Does that go to the normal courts? What's the dynamic there?
I think to answer that question, it's best to start perhaps with the point that historically Singapore has always been a commercial center. And so the ordinary courts, the High Court in Singapore, has always had a kind of commercial focus. And in a way, it hasn't so much been a need to separate the commercial court from the other aspects of the High Court's work as to separate some of the other aspects. So in the last 10 years, we have completely reformed, for example, our family justice system. And it's moved away from a very sort of civil, disputes-oriented kind of system. And that's because you need the appropriate types of dispute resolution for the appropriate types of case. Historically in Singapore, our justice system was probably quite geared towards dealing with commercial matters because Singapore was a commercial center, whether for shipping, for trade, for commodities, all the rest of it. And so that was very much the bread and butter of the courts.
So to summarize, we have gone from general to commercial courts, but Singapore already had the commercial court tradition within the normal system, and other parts which were non-commercial have been hived off, is broadly how I understand what you're saying.
Absolutely.
Correct.
Yeah.
Okay. So that's obviously you've come come from it from a different point because of your history and as opposed to ours. Yes. So let's proceed one step further. So we've got an idea of how these commercial courts came up. But if I can ask Justice Varma, what are those features of our commercial courts that you find special as opposed to normal litigation? And what are the features you like, and what are the features that you really don't like, if any? What are those features? Yeah, you've been a commercial court judge, original jurisdiction, appellate jurisdiction. What are those aspects that work for you?
Well, firstly, like you said, for us it was a move from the general to the commercial. And this was embodied in our 2018 amendments when we brought down the pecuniary limits for matters which could go to a commercial court division or a commercial court per se. And I think broadly our focus was also with the fact that we were opening up right from the 1990s, post-1990s. We'd come up with the focus being on India being easy on business, being business-friendly, and thus enabling the settling of disputes which arose out of commercial transactions. And in that sense, the structure that we've now set up is answering to those needs, be it in the form of case management hearings, which was a concept which was earlier unknown in civil litigation. We mentioned pre-institution mediation. And it's very interesting to read some of the statistics because I see from the disposal of cases both at Bombay and Delhi, approximately 47% of the cases which are laid at the door of commercial courts there are getting disposed of at the mediation level itself. So that kind of represents a huge paradigm shift so far as handling commercial litigation is concerned. Otherwise, historically, we all know historically how the system worked. And the other aspect is the cutting down of the number of appeals that you could take in the course of a litigation. So now you have 13(1)(a) in our act, which does away even with the letters patent, at least cuts it off completely, and provides only a specific genre of orders or decisions against which an appeal could be taken. And I think that's a good way of trying and cutting down the course of a litigation, and which is what the people engaged in commerce and trade are actually looking forward to.
So this statistic is very interesting. I had no idea about this, but just to summarize what you're saying, obviously the Commercial Courts Act has brought in a lot of changes. You mentioned limited appeals. You mentioned case management. I will ask you how practically case management works, because as a lawyer, one has had varied experiences on how case management works. So I wonder how you see it from the judicial point of view. But certainly I did not realize, so Justice Jeyaretnam, we have an act which provides for compulsory mediation in commercial matters. And what Justice Varma has just told me, which actually shocked me, is 47% settle. And this is for India, where we are pretty litigious. So obviously something of the Commercial Courts Act has worked. I had heard very different versions about this 12A mediation. In fact, the Supreme Court passed a judgment saying it was pretty much compulsory, except if you get interim relief. But I mean, this is something I've learned, which I didn't know, that there's been massive push towards settlement. But since you mentioned, limited appeals and such, one of the provisions there is summary judgment. What is your experience of summary judgment? Before you answer, I've not had a very happy experience in the couple of matters one has tried, but obviously you have a wider range. So have you seen whether it's working or not, or do you have applications for summary judgment?
So I've seen both parts of the coins. I've seen lawyers with all due apologies, with their usual dexterity, resorting to the summary judgment resort more than often. But we've also seen matters getting settled on a summary judgment application. And the tests which are formulated are pretty clear, and they are as old as they were when we had the summary judgment provisions even in the CPC in our code. And I've come across a huge number of matters where that particular avenue was actually resorted to, and it's worked well.
So if I can come back to you, our act has a number of provisions, as Justice Varma said, imposition of costs, then summary judgment, disclosure requirements which are quite tight, fewer appeals, a number of variants. We've amended our CPC to try and get our commercial courts up and running. All this has happened. But I want to now ask you, what is the equivalent in Singapore, and can you tell us a little more about the SICC? Because this seems to be a peculiar creature only in Singapore. I mean, everybody has their commercial courts, but this seems to be slightly different from the outside. So if you could tell us a little bit about it, and what is different, and what are the similarities from what you hear?
Certainly. I think you're absolutely right. I wouldn't use the word peculiar. I'd use the word unique.
Unique.
So
okay.
the Singapore International Commercial Court is indeed unique. And again, just historically, I mentioned earlier that Singapore's courts have always been dealing with commercial disputes. And of course, we also have been doing it in the English language, and so that meant that there was no need for the for Singapore to set up a separate English-speaking, commercially oriented court, as has been done in places in the Middle East, where you didn't have local commercial expertise and you didn't even have proceedings in the language of international business, which is English. So the reason why we set up the International Commercial Court was responsive to the growth and development of Singapore as an international dispute resolution center. And that meant that was matters coming to Singapore for arbitration, matters coming to Singapore for resolution in our courts, matters coming to Singapore for mediation, and in those cases coming to Singapore where perhaps there wasn't very much of a connection with Singapore itself. And that probably makes it a different kind of market, legal market, from the market that you have here in India. And so it was the international aspect of it that the SICC was addressing, and in two principal ways, which then has a special, unique outcome. So the two principal ways in which we addressed it is, one, by having, in addition to our Singapore judges, our commercial Singapore judges, we have, of course, in terms of numbers, it always sounds a bit small compared to such a wonderfully large and dynamic country as India. But we have, on our bench of 30, we have 8 to 10 of our judges with deep commercial experience, really deep commercial experience. But then bringing in international judges, leading judges, just retired from common law countries, former chief justices, and not just common law countries, but also civil law countries. So France, Japan, China so far, and of course our intention is to continue to bring in international judges from other legal traditions. Why? Well, let me then go on to the next point. The other internationalization of the court is to facilitate the audience rights of non-Singapore counsel in proceedings before the SICC. And so today, if we have a case which involves, say, Indian law aspects in front of us, we will be addressed by Indian counsel directly. We won't be hearing Indian law as a fact, a finding of fact, with a professor from an university in India coming to give evidence. No, we'll be hearing directly from counsel, arguing not just what the law is, but how the law applies to the facts. And so that's makes it very different. Now, those two things together, the internationalization of the judges and the internationalization of counsel, comes to a third point which is very important, and which I can segue a little bit back to the business of our commercial court as a whole after that. And that point is this, that really effective civil procedure these days does not find its root only in one legal tradition. We actually have to be actively incorporating best practices from various legal traditions. And for example, I think Justice Varma spoke about case management. So active early case management is very critical. In a way, it comes, to some extent, it's something developed in arbitration. Case management is also something which is done in civil law systems, but perhaps in a slightly different way. And we have brought it in. We use it in a very active interventionist way to frame issues early, to fix the timetable and procedures that are going to take place in the case early, so that you know when your case is going to end. Once it's filed, you know when it's going to end, what you have to do to get there, and how long you're going to wait to get your judgment. And so it's a constant process of reform, tweaking, looking at procedure, how different things fit together. And perhaps then to just respond to one other point which was raised by you, Gourab, which was about summary judgment. And it's just as an illustration of how things, something that you do in one area affects things in another area. When I started practice, which was an awful long time ago, we had a terrible backlog of cases. And so you would after you closed your pleadings and so forth, the case would then sit for several years before it came on for trial, and you would take it out from the warehouse for trial. In a system like that, everybody would try for summary judgment, because that was the only way you could get your case decided within a reasonable time frame. Today, our cases are dealt with very quickly. So actually, hardly anybody goes for summary judgment, because summary judgment is difficult to get if there is any dispute of fact on a material issue. And if there's no dispute of fact on a material issue, well, then you can go under a different procedure. We have other procedures which can get you to a very quick resolution of the case where there's no materially disputed facts. So summary judgment has pretty much fallen off as a practice. We still have it in our books, and occasionally people mount it, but it's a rare case where it is really necessary or useful.
So let me go back to Justice Varma. What I sense and hear from Justice Jeyaretnam is that the SICC has tweaked the procedure and is evolving a sort of more hands-on procedure with civil law elements in order to sort of deliver quicker, better justice. So in that context, I mean, we hear about arbitralization of commercial courts. You have been, sir, in charge of revisiting the commercial court rules. And obviously, some of these issues would have cropped up. And particularly since we're talking about arbitration and then the courts supervising it, commercial court supervising it. What has your experience been in, and what is your thinking, or the court's thinking about these commercial court rules that you're tweaking, summary judgment, other innovations? How have you, because obviously your sort of target and your problems are much greater than that of Singapore, and obviously you have to look wider. How are you tailoring this, and particularly in the context of the fact that the value has been reduced from, I think, 1 crore, 2 crores to 3 lakhs. So suddenly you're being flooded with commercial causes. How does this commercial court's rule fit into this picture?
So from what I can gather from what Philip said, so the Singapore experience with the SICC, I think, was predicated on them being able to create a forum which would take care of international commercial litigation, so to speak. When it came to us, of course, we were dealing with commercial disputes, not just international disputes, and therefore we had to come up with a structure which would work pan-India. And in that sense, the lowering of the pecuniary limits, which enables parties to approach a commercial court, I think it was a welcome step in the sense of freeing up our ordinary civil backbone to deal with just matters with a purely civil, and then completely removing commercial disputes from the ambit. As you're aware, it's not just the high courts which function as commercial divisions and appellate divisions. Every district in every nook and corner throughout every nook and corner, breadth of the country, you have your district courts which have their own commercial courts. And therefore we had to kind of strike a balance between the needs which would meet the litigant, not just in the big metropolitan cities, but also in the heartland of our country. Because you can imagine the kind of disputes which would arise out of, say, a simple real estate transaction in a small corner of the country. Or on the other end of the spectrum would be a shareholders dispute or a JVC dispute. So 1 crore for anything which comes up to the High Court level and everything else still being handled by all these district courts. And so therefore, our rules have kind of tried to strike a balance between the needs of both tiers of this resolution system.
So my arbitration friends must be wondering, I'm only talking litigation, so I'll quickly move on to the last bit, which is the arbitration bit. The question here is, all our arbitration disputes, whether it is appointment of arbitrators, whether it is Section 9 interim relief, whether it is removal of arbitrators, setting aside of awards, now this is all now really within the supervisory jurisdiction of the commercial court. But isn't there a tension, and this I will ask Justice Jeyaretnam, of course, and put him on the spot on this one. But first I will ask Justice Varma, isn't there a tension between, basically supporting the process and then sitting as a commercial court judge trying to do justice and take over the process? Do you not feel it in some cases where you find that there has been significant injustice at the arbitrator level? How does this, I'm sorry to, I'm not giving
I
examples.
thought you said you were wanting to put Justice
I
Jeyaretnam
will,
on the
but
spot.
before that, but on a more serious note, where does one draw the line in terms of supplementing as opposed to supplanting? I mean, how would a commercial court judge do it? And more importantly, I mean, we know, I mean, you maybe a Delhi High Court judge, maybe a High Court judge may be better experienced doing it. But you mentioned that there are so many commercial courts which are there at a different level. Is there a requirement of any training? How does one tackle this problem?
To tackle the last one first, training or upskilling your knowledge of becoming aware of good practices which are adopted by other institutions. That's something which should be done not just by commercial judges at the district court level, but perhaps even High Court judges should be open to it.
So forbid Supreme Court judges also.
I won't go that far.
Don't go that far, right? Okay.
But so far as appointments is concerned, hopefully as India transitions to an institutional-based arbitration and finally brings this ad hoc appointment system to a close, we would have a more structured, a more fair, and a more balanced appointment procedure to be adopted. Injunctions, interim measures under 9, we found that it is a necessary tool which the commercial judge must have. And it's been rightly placed in the hands of all commercial judges in commercial courts universally, be it at the district court level or at the High Court level. And in my little experience, intervention with arbitration proceedings, perhaps High Courts have been more trigger happy than the district courts. And we found very few instances where, the district courts may have intervened or treated the arbitration process or interfered with proceedings before a pending arbitral tribunal. When it comes to 34, you are more than aware of the shifting boundaries of intervention. Right. And it's become more of a case of a case-wise based intervention in how a particular judge may perceive the manner in which it should have been decided. So patent illegality has become kind of an unruly horse, I feel, and so that's something that
I
needs
wanted to defend patent illegality by way of an anecdote. So this expression, we have this defense for domestic arbitration, setting aside domestic arbitration awards, where the extent of intervention is more than international commercial arbitration. I'm sure most of you know this, but this is completely off topic, but I can tell you an interesting anecdote about this. So where did this phrase patent illegality come from? Where did it spring from? How did this happen? This was a matter all of you are familiar with, ONGC and saw pipes. and Justice M.B. Shah is credited with this phrase. But I was assisting the late, great Mr. Ashok Desai, and I had proposed something called manifest disregard, which is a phrase used in some US judgments. But actually, Mr. Desai, while arguing the matter, on the fly, came up with this term. So he should be credited with this particular phrase. And there was a huge backlash. There was a, I think Mr. Nariman said that this is, we are going back to the 1940 Act. There was an LQR article saying judicial ambush. But in the 2015 Act, we brought it back. And AP Shah, Justice AP Shah is by no means anti-arbitration, and maybe we need greater degree of supervision for our domestic awards, seeing some of our domestic awards. Maybe it's better that the judges rule in the unruly horse of arbitrators. I don't know, but that's a topic for another day. Let me put my case to Justice Jeyaretnam. The question I have is a little different. Singapore is this great seat of arbitration. You've got the SIAC, you've got a full-fledged system set up. Why on earth do you have the SICC, which is perceived by some to be directly sort of antagonistic to the well-settled, easy mode of arbitration where you can enforce an award under the New York Convention, whereas when you get a judgment from the SICC, enforcement issues do arise. I mean, that's the elephant in the room. How do you, as the president of the SICC, reconcile, that issue, or how does Singapore look at that issue? Do you not supplant, as our topic says, are you not supplanting rather than assisting arbitration?
Okay, well, Gourab, you're being very provocative, and I'm, of course, duly provoked. First of all, to say that I think the perceptions you have deliberately, I think, are, of course, at least overblown, if not completely wrong, I suppose, to put it bluntly. But let me try and answer the question in a slightly more sort of holistic way, with a few sort of preliminary points. And the first thing I wanted to say is that, philosophically, courts are essential to arbitration. They are essential because justice ultimately is what you find in the courts. And if you simply had a system of arbitration, as you did before, national institutions like courts arose, and cases were simply decided in private, confidentially, among parties to disputes, well, I mean, it might work most of the time, but you wouldn't be developing jurisprudence. You wouldn't be building up a body of law, which is what you get from court decisions. So court decisions are essential. I mean, you can't run away from that. And so you need commercial courts, and specifically, you need international commercial courts when you have this growth of cross-border disputes. Now, then practically, the second point is practically, courts perhaps fulfill, first of all, a somewhat different function. So in the SICC, we of course we do have chosen court jurisdiction for commercial disputes. Parties may choose the SICC, and they do. So they're doing so for a reason. Perhaps they want the panel of judges, perhaps they want the fact that it's open, perhaps they want the fact that you can have an appeal. But in addition to that chosen court jurisdiction, you have, for example, insolvency and restructuring work, which I think increasingly has an international flavor to it. And so international commercial courts are uniquely placed to play the role of nodal jurisdictions for restructuring and insolvency work. And I think that's quite important too. Now, coming back then, or arriving perhaps finally at what I think is the nub of your question, which is competition between arbitration and the commercial courts. Probably not a very helpful way of looking at it. We are not in competition with the SIAC, but we are the supervisory court for them, right? So we do have that responsibility of administering arbitration law in relation to awards. And that's a very important responsibility. And I think what you tend to see in jurisdiction, or maybe let me just talk about our own jurisdiction. Historically in Singapore, when arbitrations first arrived on the scene, it was when I was a young practitioner. And many of us, our Chief Justice, myself, others, were encountering arbitration for the first time, and probably a bit smart alecky about it, and we thought we knew what we were doing, but there were lots of court decisions, partly because of counsel's arguments, that were really a bit off beam, and the court was resistant to arbitration. That's back in the 90s. And then, of course, we collectively realized how important arbitration is, and party autonomy and separability of the arbitration agreement and all the rest of it. And then perhaps it swung the other way, and you got to the position where it was just very light touch, and it was sort of, there was no intervention at all. And then I think we've reached the mature position now where we have to deal with arbitration awards based on what the law is. Our law is based on the UNCSA model law. And where warranted, awards are set aside. It's a very small fraction of the total number of awards being given in Singapore, but it's part of the responsibility of the courts to deal with natural justice issues, to deal with jurisdictional issues, to deal with, indeed, public policy issues, which still continue to be thrown up from time to time. So I think it's a lovely provocative title, supplant or supplement. I would actually say that commercial courts are essential as an underpinning to any effective system of ADR, whether it is arbitration or mediation. You couldn't mediate unless you knew what your possible outcome would be in court, and you mediate against that possibility. And that's why you need to be able to have, in addition to mediation and arbitration, a court system that will get you to your final result within a short period of time. And that's how I'll end my answer to you.
Right. So I think we are at post 7 o'clock, and subject to any final remarks by Justice Varma, and I don't know what the timing is. We can have a few questions depending on what our okay. So do you want to say something, and then we can have
just to say, so coming back to the SICC and how Philip has explained it, I think each nation has to keep working on its dispute resolution portfolio. And the unique feature of the SICC, which I gather, is how it is embedded in the national court system itself, and thus has an inbuilt supervisory appellate authority. Unlike how we kind of understand institutional arbitrations, which would be totally outside our national court system, and then would have to again follow the same route of filing an appeal. And in that sense, it appears to be a more wholesome solution to parties who are desirous of having all their litigation kind of resolved under the aegis of one particular institution. So in that sense, it does set us thinking on how it could be considered elsewhere, or maybe even here.
Thank you, Justice Varma. I think that's I just wanted to clarify, of course, I didn't say, and didn't mean to say, that the Singapore courts exercise any kind of appellate authority over arbitration awards. Yeah, it's a supervisory authority based on the grounds in the model law. So we don't.
Yes, so perhaps appellate was the wrong word to choose, because even here the 34 is a supervisory.
Our law is also based essentially on the ancestral model law.
Good evening, sir. This is a question for Justice Varma. You just pointed out, as far as statistics is concerned, as far as commercial courts, 47% are settled at the pre-mediation stage. So is it because in these matters, court fees are very high and they are returned if they are settled at a pre-mediation stage?
I wouldn't say it's a question of a court fee. At least in Delhi, the court fees is not not so gigantic. That
I'm
it
talking
would-
about huge cases where the court fees are high in terms of commercial courts.
Well, so the maximum would be about a 1% of the total claim.
Okay.
So, but whatever may deter litigation, hogging court space, that would be good enough for us to consider mediation. And mediation is something that we've been giving an impetus to even otherwise, outside the ambit of the Commercial Courts Act itself. And I think parties have also now started realizing that it's easier to settle and move on when it comes to a commercial dispute than spend maybe a year in litigation.
Thank you, sir.
And brief, expensive lawyers.
I don't know whether Ms. Thier will agree with you there.
Good evening. My question actually is to both the lordships over here. And the question is, how has technology really helped the court system, the judges, that side of the corridor, to achieve the objective of dispensing fast justice? I know from personal bitter experience that my Lord Justice Varma's court is a soft page only court, but I think both Justice Jeyaretnam, Justice Varma, how has technology really helped judges or is helping judges to achieve, let's say, faster justice?
I think technology has really reached a point where it is very helpful to the actual trial process. I think when technology first came in, it was mostly to do with electronic filing and electronic storage, and so it was mostly solved that old problem of just routing of paper, right? But today it's much more than that. And so I think, for example, in the case that I'm doing at the moment, we have a very effective document management system. There's, millions of pages of documents, because unfortunately, with that same technology generates, huge numbers of pages of things. But every time it is referred to, a document is referred to, it comes up on screen immediately. Very, very quickly. And we also have it in the public gallery as well, so that somebody sitting in the public gallery can actually follow what is being asked and what the witness is being shown and what the court is being shown at the same time. And then, of course, it extends through into our decision-making as well, as to how we can then, how quickly we can make a decision, because the documents are managed better. But probably lurking behind your question is this question of when AI is going to come in and help us. So we are actively looking at this, but obviously we haven't started employing it yet. And I think it's something to be approached with considerable caution.
I have a question for Justice Varma. Justice Varma talked about case management, and our Commercial Court Acts talk about case management. My understanding is this case management concept, as Justice Philip Jeyaretnam also talked about, is it has got its origin in civil law jurisdictions, where courts are having inquisitorial role and have the active approach towards the whole litigation process, which Lord Wolf basically tried to bring in the UK, and it's Wolf's report, and then Lord injection report also. But once this case management process was brought in UK, my understanding is that it was really being used in a very effective manner, so that judges are in charge of the case. They know what are the requirements of the case. They take proactive approach. Timeline is set. Same judge will have the opportunity to deal with the matter in a timely manner. In my experience in Commercial Courts Act, and when we talk about case management in Indian courts, better we hear from you, how effective is case management in Indian judicial ecosystem?
Well, speaking from my little experience in Delhi, we've been pretty stringent, and we have extremely strict timeframes and timelines in our rules itself when it comes to how the litigation will proceed through. Personally speaking, I feel, considering the number of matters which we have in each High Court, it's very important that we stick to our case management rules, because time before a court is a very scarce judicial resource, and it has to be spread across evenly amongst all kinds of litigating parties. And as far as Delhi is concerned, we've been pretty effectively implementing our case management systems, and I see it from some of the orders which come even from the district courts, that they've also adopted very strict views towards adhering to the case management time frames that have been put forth. I don't know what has been your personal experience, good or bad, but that's the little that I've seen from this side.
Thank you very much.
Good evening. I'm Rajan Raj, Advocate, Supreme Court. I have a question for Justice Jeyaretnam. Justice Jeyaretnam, during his comments, mentioned that in the SICC, even foreign lawyers have a right to audience, and questions of foreign law are not just led as questions of fact and answered as expert evidence where a professor is heard or something, but foreign lawyers can argue on it, which is a departure from the position in Indian law where under Section 45 of the Evidence Act, foreign law is a question of fact. So what I wanted to understand is that did this require some amendment in the substantive law of evidence in Singapore or the legislation governing lawyers? And practically, when a foreign lawyer argues before the SICC, do his submissions have to be confined to questions of law, or they can extend to mixed questions of law and fact as well?
Okay, so it is provided for under our SICC rules. So yes, if we were to make the change for non-SICC matters, we would also have to make a change of the rules of court as well. So we haven't done that. So the SICC, this is one area where the SICC is different from the general division of our High Court. Then the next question you asked is, can that foreign lawyer address the court on the application of the law to the facts? Yes, they can. They can, yeah. But of course, if except for a case where there is, I mean, there are different kinds of cases. So there are cases where you can be admitted as a registered foreign lawyer to try the entire case, in which case you could also cross-examine witnesses and so forth. And there are a number of Indian lawyers who are actually registered foreign lawyers. The category of case that comes under this, they have to be cases with essentially no connection to Singapore. If they are cases under Singapore law and have a connection with Singapore, then you would need a Singapore co-counsel who would be the one who would be cross-examining witnesses and so forth, right, and dealing with facts in that sense. But I've had matters before me, arbitration challenges, for example, where we have been addressed on jurisdictional issues and by a foreign lawyer, in which they have argued the case just the way a Singapore lawyer would do, but on the assumption that that law of that country applied. And I've sat with judges who are familiar with that law at the same time as well.
Can I just add a possible additional issue to the chairman's question about the interplay between arbitration and commercial courts? Put bluntly, I think commercial courts give arbitration a run for its money, in the sense that if you look at domestic arbitration in Australia, where I come from, or in England, domestic arbitration, there is a preference to go to the courts because the commercial courts there in both countries provide a far more effective dispute resolution process than arbitration. So domestically, arbitration needs to pull up its socks to survive. And commercial courts are very useful in making sure that arbitration does not fall into a lull of security and not reform. Internationally, I think there is also an opportunity for commercial courts with the speed of judgments, the capacity to deal with multi-parties that give arbitration a real challenge. And it's good for arbitration that there is that competition. Any major commercial centre in the world has commercial courts and arbitration. New York, London, Singapore, wherever you may look.
So I sense that is sort of a reaction to the provocative question I had. But there's one other little point there which bothers me, which is I go to the Singapore Commercial Court and I get a judgment in my favor after 1 year. It's heard out, everything is fine. But if it's an international court judgment, isn't there a bit of a problem enforcing it when I bring it back or bring it to India or somewhere, as opposed to if I go to the SIAC and get an award and enforce it under the New York Convention? I mean, isn't that a bit of a problem?
Well, I'm not going to, well, actually I am going to speak to India as well, because we have had Singapore judgments enforced quite quickly in India, and actually for quite a long time. In practice, I remember 15 years ago, I had a case, judgment was enforced within about 9 months, which was, I think, not bad at all. I think that was in Hyderabad. I don't think it's a real difficulty. But maybe to answer it more systematically, perhaps, one has to remember that the New York Convention arose because arbitration awards were harder to enforce than judgments. And so it is true that the New York Convention now covers a lot of countries. But if we look at judgments out of Singapore, I mean, on our analysis, there are a number of different buckets, and most countries fall into one of those buckets. So, for example, there are the Commonwealth, the old Commonwealth kind of procedures.
We do have some provisions,
Yeah,
like 44A,
yeah.
reciprocity.
Yeah, which are actually statutory and really emanate from there. And so India is one of those countries. But there are other buckets as well. We have, the Hague Convention, Choice of Courts Convention, which essentially gets us enforced in the whole of the EU. And then there is, common law or civil law enforcement. And we have had judgments enforced readily in the US, in China, in Japan, and vice versa, of course, because it's also on a presumed reciprocity basis. So with those 4 buckets, actually you cover pretty much everywhere, with one exception, but I'm not going to name the place, but try enforcing an arbitration award there, you may have difficulty too.
Otherwise,
yeah.
I have a question for Justice Philip Jeyaretnam, sir. Upon a preliminary research, there are 17 international judges in the SICC. So I had a question regarding how judges are assigned to preside over cases. So for example, there's Justice Arjun Kumar Sikri from India in the SICC, and there are justices from various countries around the world. So when an international matter comes before the SICC, how is a judge selected to preside over a matter?
Okay. Well, the criteria for assignment of judges, first of all, there is a question of how big the quorum should be. So we have either, for first instance, we have either a quorum of 3 or a quorum of 1. If it is a single judge, then it's going to be one of our international judges. If it is a quorum of 3, then we have a presiding Singapore judge, Singapore commercial judge, and then we have 2 international judges. So then the question of the actual allocation would then depend on, I mean, there are 2 possible relevant factors, apart from, of course, things like availability and so forth. The other 2 possibly relevant factors would be familiarity with any foreign law in question. And then the second factor would be subject matter expertise. So we have both in among our Singapore commercial judges as well as our international judges, people who are experts in different fields. And for example, Justice Jones, Professor Jones is one of our international judges, and he's a world expert in construction. So it would be an immediate match for that sort of case. And similarly, I could repeat that, going around the rest of the bench.
Okay, I think we've run out of questions, and I think we won't hold you back from the cocktails and dinner, so over to you.
Thank you so much to the speakers for such an insightful and interesting discussion, and for triggering that sort of an interaction in the legal fraternity. As our very honorable and learned speakers are still on the dais, I would please like to take the opportunity to request Mr. Ratan Singh to please come on the stage. Mr. Singh is known to all of us, senior advocate and arbitrator. He's member of the International Eating Chambers, London, chairman of the Society of Construction Law, India, and also director of the Chartered Institute of Arbitrators, India. I would please request you, sir, if you can please come on the stage, and please welcome the speakers and the delegates of the forthcoming SCL conference, which starts from tomorrow. We at KPMG are extremely honored to host the speakers and the delegates of the SCL conference, extremely mindful of the fact that there's a formal welcome which is being hosted by SCL itself. But sir, please do accept this honor from KPMG as well. Thank you.
Thank you, Gitu. In fact, I hope to see most of you tomorrow in the SCL India's 4 biennial conference, which is starting tomorrow, 5 o'clock. My Lord Justice Philip Jeyaretnam is going to deliver a special address tomorrow in this SCL India conference. Mr. Gourab Banerji is going to give a speech in SCL India conference. I had visited, in fact, my Lord Justice Varma with a request to speak in the conference. But due to preoccupation and conflict of diary, I couldn't get his time. Mr. Doug Jones is sitting in the audience, and Mr. Doug Jones is tomorrow going to speak in the first inaugural session, which is on collaborative contracting, which is a very new concept. And in fact, I still remember in the month of April in Singapore, with my co-fellows, Mr. Philip Jeyaretnam and Mr. Doug Jones of IACL, International Academy of Construction Lawyers, we discussed about this concept, collaborative contracting in closed door for 3 days. And thereafter, we had a visit to Singapore Supreme Court and had meetings and lunch with judges. And then we had one session in Singapore Supreme Court. So that is one topic, very interesting topic, which is very new for the Indian industry. We are going to talk about. And then next 9th and 10th, we will have a whole day conference in IIC. Tomorrow it is in India International, tomorrow it is in Heroes Nehru Place. And we are starting 5 o'clock. We will have Mr. Alexander Nishan, who is head of Keating Chambers. He head of my chamber. And also ad hoc judge of technology and construction court. So we will have essentially 3 foreign sitting judges who are deciding and presiding over construction disputes, speaking in this conference. We have 23 foreign speakers who are all doyen and great personalities in construction industry. So hoping to see you, all of you, tomorrow in the conference. I see Mohan sitting there. Hi, Mohan Pillai is in audience. He's also going to speak in our conference. Mohan is surely the finest construction lawyer in Singapore. Gitu is going to speak in one of the sessions as quantum expert. So Mr. Tejas Karia, my co-chairman and my active member in the organizing committee, Mr. Shashangar, they all are speaking in the conference. Ladies and gentlemen, it is going to be 3 days stimulating exercise, I would say. And we have on-spot registration as well. So anybody who is left behind can join us. And thank you, Gitu, for allowing HCL speakers and delegates to be part of this event, which we started calling pre-HCL event, which I'm encroaching upon this, which I shouldn't have. So thank you very much. Thank you, Justice Varma. Thank you, Mr. Gourab Banerji. Thank you, Justice Philip Jeyaretnam. Thank you very much.
Pleasure is ours, sir. Thank you so much. On an ending note, I have to say that on behalf of the entire KPMG leadership team, we are extremely grateful to all our speakers today, and a very big thanks to Honorable Justice, Mr. Justice Philip Jeyaretnam, Honorable Mr. Justice Yashwant Varma, and Senior Advocate Mr. Gourab Banerji, and Mr. Ratan Singh. Thank you so much. Thanks a lot. Extremely grateful that IAF and EBC and SCL gave this opportunity to us at KPMG today to host this evening. And we would not want to hold you back from the cocktails and dinner. And I have to say that we are extremely, we take this as a very pleasant opportunity to celebrate the onset of the winter season and the festive season. So the bar is open now. And after, I think, a hard day, I'm sure everybody, all of us have had a long day. So it's good time to unwind ourselves with a nice glass of wine and some good food. So thank you so much.